Welcome to Consumer Connection. My name is Susan Jones, Branch Manager with Fairfax County Consumer Affairs. I have with me today Colleen O'Conor, Housing Attorney for Legal Services of Northern Virginia. Welcome, Colleen.
Thank you, Susan.
Today's topic is on tenants' rights and responsibilities by Legal Services of Northern Virginia. So, Colleen, let's start off by you telling me a little bit about Legal Services of Northern Virginia.
Thank you, Susan. Legal Services of Northern Virginia, or LSNV, is a nonprofit civil legal services provider. We assist people in Northern Virginia on a variety of civil legal issues. For the most part, the people that we assist are low income, have disabilities, or are elderly. And we provide assistance on issues including family law issues such as custody, divorce, protective orders, public benefits, access to health insurance, consumer issues, as well as housing, which is the area I practice in.
So how does this process actually work?
Sure. If someone's interested in applying for free legal assistance through our office, the first step is to contact us to start the application. There are 3 ways to apply for assistance through our office. You can apply by phone Monday through Thursday from 9:30 a.m. to noon or 1:30 p.m. to 3 p.m. Our phone number is 703-778-6800. Second, you can apply online anytime by going to www.lsnv.org. Or third, you can apply in person on Wednesdays at one of our local offices. Our office in Fairfax is located at 10700 Page Avenue, Suite 100, Fairfax, Virginia, 22030, and our hours for walk-in Wednesday are 9:30 a.m. to 4 p.m. However, we're closed for lunch from 12 to 1:30 p.m.
So, Colleen, you mentioned housing as one of the areas Legal Services in Northern Virginia addresses. What are some of the issues that you actually receive?
The bulk of what I work on is eviction defense, representing tenants who are facing eviction from their landlord at different stages in the process. We assist tenants who live in public housing as well as private housing. Additionally, we work with people and represent tenants in lawsuits against their landlord when their landlord does something that makes it unsafe in their home. For example, if the landlord changes the locks and abruptly locks the tenant out of their home, if a landlord shuts off the utilities, shuts off the water without any notice, or if the landlord is refusing to make really critical repairs, such as refusing to repair the heat or refusing to repair burst plumbing.
So tell me a little bit about the eviction process in Virginia.
The most important thing to know is that it is a process. There's multiple steps in the process that a landlord must go through before a tenant is legally required to leave the home. It is not the case that a landlord can just change the locks if they believe that the tenant has violated the lease in some way. So first, a landlord must issue some type of termination notice if they believe that the tenant has violated the lease or overstayed the lease in some way. If the tenant doesn't leave or fix the issue when the notice expires, at that point, a landlord can file a summons for unlawful detainer to begin an eviction case in court. A few weeks after the landlord has filed the eviction case, there will be a first hearing date. This is known as a first return. And if a tenant appears at that first hearing date and disputes the case will generally be set for trial a few weeks after that. If ultimately an eviction judgment is entered against the tenant, if the tenant loses the court case, even then, there's still additional steps a landlord must take. So the landlord cannot change the locks the day that a tenant loses the court case. No eviction will happen for at least 10 days after an eviction judgment is entered against a tenant. A sheriff will post a piece of paper on the tenant's door with the date and time of a scheduled eviction at least 72 hours, so at least 3 days, 72 hours in advance of any eviction. And it's important that tenants know that throughout all of these steps, there may still be things that a tenant can do to avoid eviction. For example, in some instances, such as cases that are about unpaid rent, about owed rent, a tenant may still be able to redeem, to pay everything that they owe and stay in the property up until 48 hours before a scheduled eviction.
So what happens if you're behind on rent? Do you just simply need to move out?
No. If you are behind on rent, there are several opportunities that you have to pay the full balance, catch up, and be able to stay. The landlord cannot just change the locks. The landlord must go through the process that we just mentioned by first issuing a termination notice. An unpaid rent, it would be a 5-day notice telling the tenant they have 5 days to pay or the lease will terminate.
So what if there is not even a written lease?
This comes up a lot for us, where tenants are concerned because even though they've been living in a property for a while, they pay the landlord rent on a monthly basis or a weekly basis, they're aware that they don't have a written document and are concerned that this may mean that they are not afforded the same protections under the law. But in Virginia, if a landlord does not offer a tenant a written lease, a tenant automatically has a 1-year lease. So Virginia law makes it so that if there is basically a verbal lease because the landlord has not given the tenant a written lease, a tenant has a 1-year lease, and after that 1-year lease term expires, it will carry over month to month. So even these tenants are afforded the same protection under the law.
Good to know. So what if my landlord gives me a notice saying I have 5 days to pay or quit or move out?
Sure. So for many people, when they receive this type of notice, it can be very nerve-wracking. You get a notice saying, I have 5 days to move. I think the first thing is the notice will say, or should say, if it's a legally proper notice, exactly how much it is that you would need to pay in order to cure or fix the issue. So if you are in a position to pay that total amount within the 5-day period, you can pay that. Recommend that you do so either with certified funds or get a receipt so that there's a proof of your payment. And if you pay the full amount off during that 5-day period, your lease does not terminate. You continue on in your tenancy just as normal. If you are not able to pay in the 5-day period, then at that point, your lease may be terminated and your landlord can take the steps to begin a court case by filing a summons for unlawful detainer.
So what if I'm withholding rent because of some of the bad conditions?
This is a great question. This comes up a lot where tenants very understandably feel like, I am not being given a good living space. My landlord is refusing to fix the mold, refusing to get rid of the pests, but I am just paying them month after month in Northern Virginia where rents are very high. And so I think very naturally sometimes tenants will feel like, oh, well, I should withhold my rent to sort of give me leverage. In Virginia, though, unfortunately, tenants are not able to withhold rent. They cannot just withhold their rent because of bad conditions, and if they do so, they are breaching their lease, and the landlord can take steps to begin the eviction process for unpaid rent. There are several mechanisms that a tenant can use to try to enforce their rights to a habitable home, to try to force their landlord to make repairs. One of those is a tenant's assertion court case process. Another is a repair and deduct process. But those are very specific processes with very clearly defined steps. And so just withholding rent really can make a tenant at risk of being evicted.
So what is a summons for unlawful detainer?
Summons for unlawful detainer is the court form that starts an eviction case. Once a landlord goes to court and files this court form, it will be served on the tenant either by the sheriff or a private process server. They'll either serve it personally on the tenant or post it at the home. It's good to look at the summons for unlawful detainer form very carefully if you receive it, because it has some helpful information. It will list the reason that the landlord believes they should be able to evict you. For example, it'll say this case is about money, here's the amount of money that's owed, or this case is about some type of lease violation. For example, you've been too loud or you have too many people living at the premises. And then also the summons will say the date, time, and courtroom for that first court date, which you're certainly going to want to pay close attention to.
Now, should I go to court? What happens at the first court date?
Yes, yes, you're gonna want to go to court. And honestly, going to court is very stressful. Many people feel like, well, I owe some money. Should I even go? It's scary to show up, and who knows how it'll be. But the first hearing is a first return hearing. It's important to be on time. If you do not show up, a default judgment will generally be entered against you. So generally a tenant will lose their case without ever even having the opportunity to assert their rights or ensure that any judgment that's being entered against them is proper. So when you go to court, you'll go into the courtroom. In Fairfax, generally there will be many eviction cases in this return docket, in this courtroom, all scheduled for the same time, and the judge will call through the cases one by one. If you need interpretation, you can let the judge know when the judge calls your case that they should provide an interpreter. But once the judge calls your case, you walk to the front of the courtroom and the judge will ask you some type of question. It's phrased a little bit differently depending on the judge. Sometimes it'll be, do you admit or deny what the landlord is claiming? Do you agree that you owe this and therefore a judgment should be entered against you? Or do you dispute this and ask for a trial? The important thing to know is the court is asking you, do you agree that the landlord's right in everything that they're saying? Therefore, you should lose the case without having a trial and the next steps happen for you to be evicted? Or do you think that you might have a defense and therefore a trial should be scheduled for a different day that's usually 1 to 4 weeks from now? Additionally, if you ask for a trial, the court may order the parties to file written pleadings. This is just a written document where each side is describing why it is that they believe they should win the case. So the landlord would first be ordered to file a bill of particulars. That's the written document. It's sort of a lengthy name for the written document. The landlord files the bill of particulars. That will be due on a specific date. And then a few days or maybe a week or two after that deadline, a tenant is required to file what's called an answer and grounds of defense. That has to be filed in the clerk's office and also mailed to the landlord's attorney or the landlord themselves. And importantly, if the tenant misses that deadline, if the tenant just shows up to court with their document filled out rather than filing it on the specific due date, very often the tenant will automatically lose their case without a trial. So it's very important to pay attention to what the court is ordering you to do at the return hearing and to comply with all of those deadlines.
So what happens after an eviction judgment is entered into the court?
So if a tenant loses the case, nothing happens that day. Very often we'll see people leaving the courtroom thinking, I cannot go back to my house. That is not the case. Even if you lose your case, nothing happens for at least 10 days. The soonest that an eviction can be scheduled for is after the 10-day appeal period has ended, so it's 11 days afterwards. Very often, though, it'll be closer to 2, 3, 4 weeks from the date of the judgment. Right when you're leaving court, you won't know exactly when the eviction might be scheduled for, beyond the fact that it'll be day 11 or afterwards. But a tenant will get some advance notice. The sheriff will post a piece of paper on your door at least 72 hours in advance of the eviction. It'll say the exact date and time that the sheriff will be coming along with a property manager or someone to change the locks, so that you know exactly when it is that you'd be facing eviction.
So what is the right or redemption, or the right to pay and stay?
The right of redemption it's a very important and powerful right for tenants. So if a case or a legal issue is just about money, it's not about a tenant having violated the lease in some other way, it's not about a tenant staying past the end of the lease, it's just about unpaid rent. Generally, a tenant has the right to pay everything that is owed and still stay in the home. There's a few important details that a tenant certainly wants to be aware of when they're doing this. First, the tenant must pay everything that is owed in order to pay and stay. That includes every single month of rent that's due, all late fees, money damages, attorney fees, court costs. A tenant must hit a zero balance. And so if a new month of rent has come due, it also has to include that new month of rent. Because if the tenant pays a part or even most of what's owed, but not all of what's owed, the tenant has not redeemed, and a landlord can still move forward with the eviction process. There's a few time periods that a tenant can use this right of redemption, or this right to pay and stay. Before an eviction judgment is entered by a court, a tenant can pay everything, hit a zero balance, and that eviction case must be dismissed. So the tenant will avoid an eviction judgment on their record, which is a very good thing and can make it easier to find housing in the future. If a judgment has been entered against the tenant already, but the tenant is still in the property, has not been evicted by the sheriff yet, even then, the tenant does still have the right to pay and stay in many instances. And a tenant has the right to pay everything that's owed up until 48 hours before the scheduled sheriff's eviction. In this case, if a tenant paid everything that was owed after the eviction judgment was entered, but more than 48 hours before a sheriff's eviction, the eviction would have to be canceled. The landlord is required to cancel the eviction. The eviction judgment still stays on the tenant's record. Instead, the eviction judgment is marked satisfied, but the tenant would be able to stay in the property. A tenant who is using their right of redemption must use certified funds. The law requires that the tenant pay, for example, with a money order or cashier's check. And a few other notes. Most tenants, the vast majority of tenants, can redeem. They can pay and stay an unlimited number of times. There are a few instances where a landlord can limit the frequency with which a tenant can redeem, but it must be a small landlord who does not own many properties, who has included this in the lease and given a tenant notice. There's very specific instances when that would be the case. A tenant who is redeeming, and this will just be my last note on this, a tenant who's redeeming, especially if it's a large amount, really should ask the landlord in writing for the amount that they would need to pay in order to redeem. You don't want to make a large payment to a landlord and then you're off by $50, $100 and still get evicted, but don't have, somewhere to move to or money for hotel space. The law requires that if you ask the landlord for the amount that you need to pay to redeem in writing, the landlord is required to tell you in writing how much it is that you have to pay exactly.
Good to remember. So what is eviction expungement?
Sure. So this is a relatively new process that's available to tenants in Virginia. Eviction expungement is the process where the court removes the record of an eviction filing from the online court website and also destroys the physical case file. So basically it, for the court's purposes, removes the record that a eviction case ever existed here.
So when can an eviction case be expunged?
An eviction case can be expunged if the tenant essentially won or had a positive outcome in the case in some form. Importantly, if a judgment was entered against you, which might be the very instance in which you would hope to expunge it, eviction expungement is not available. It is only in cases where there was a judgment for the defendant, the tenant, or the case was dismissed with or without prejudice, or if the case was non-suited, which is also similarly a term for dismissing a case without prejudice. If the eviction case was dismissed or there was a judgment for the defendant, that case is eligible to be expunged 30 days after the final court date. If a case was non-suited, that is eligible to be expunged 6 months after the final court date.
So what is the process to expunge?
It depends. So the law on this changed on July 1st of 2024. So if your court case was filed before July 1st of 2024, then you would need to file a petition for expungement. This is just a one-page court form. It's available online. It's available in the clerk's office that you can fill out. It's very straightforward. You file it in the clerk's office, and a judge will look at it in chambers. There is no hearing on it. It's free, and the court will mail you the decision saying if your case was expunged. If the case was filed after July 1st of 2024, in most cases, the expungement is now automatic, which is great. In most cases, a tenant will not need to do anything for upcoming court cases that are dismissed or non-suited. The court will take care of everything after the relevant time period has elapsed. The only exception to that, because it's just complicated enough, is if a case was filed after July 1st, 2024, but ended in a judgment for the defendant, then the tenant still would have to file this exact same petition for expungement, asking the court to expunge the case.
So, can a landlord actually change the locks or cut off the water?
No, it's a big no, and I've sort of alluded to this, but self-help eviction, just forcing a tenant out of the home without going through all of these steps that we've been discussing, is absolutely not permitted. And there is a court process that a tenant can utilize if their landlord takes one of these actions. It's called a petition for relief from unlawful exclusion or a petition for relief from diminution of services. And so a tenant who found themselves in this instance, I certainly would recommend reaching out for legal assistance right away, because obviously when this happens, it is really an emergency that really can threaten people's safety. But also a tenant can just themselves go to the clerk's office in Fairfax, that is room 211 in the Fairfax courthouse, and fill out this form. Because this is an emergency hearing, by statute, this has to be heard by a judge within 5 days of filing it. It has to be heard very quickly because of the recognition that if you're locked out of your house or if your kids don't have running water, there can be serious consequences very quickly. And the court can order a few different things in this case. First, the court can order that the landlord fix whatever it is that they've done, that they let the tenant back into the property, that they turn the water back on. But also the court can award pretty significant money damages. So that includes your actual damages, the amount that you had to pay because you were, for example, locked out of your home. So if you had to stay in a hotel because you were locked out, that would be an example of your actual damages. This code section also allows the court to award statutory damages of either $5,000 or 4 months of rent, whichever is greater. So that's a pretty significant penalty for a landlord who takes this action. Additionally, a court can award the tenants attorney fees and court costs.
So where can I find legal help with the housing issue?
So we talked at the beginning, certainly recommend reaching out to my office, Legal Services in Northern Virginia. Again, that's www.lsnv.org, or by phone, 703-778-6800. But there's a few other resources as well. Fairfax County, actually, our courthouse has the very first self-help resource center available to people in the state. It's located on the first floor of the courthouse in the library and has a lot of good resources on a number of legal issues, certainly including resources for tenants. Additionally, there is a new website that was created by the Virginia Poverty Law Center called the Eviction Defense Center, and a tenant can access that website at www.evictiondefensecenter.org, and that's a great resource because tenants can input a little bit of their information, where they are in the eviction process, whether they have subsidized rent or rent from a private landlord. They can get sample motions, a lot of good information about where they are, what the timeline is, and it's all done in very accessible, plain language. It's a great resource for tenants in Virginia. And then finally, I'll just mention, if you're a tenant who may be in a position to hire an attorney, you certainly could reach out to the Virginia Lawyer Referral Service at 1-800-552-7977 to be set up with a private attorney for a consultation where you could decide whether or not you wish to retain that attorney.
Well, Colleen, thank you so much for joining us today to provide information to tenants on the eviction process and where to find assistance. Now, if you have a consumer issue, please contact us at 703-222-8435. You can like us on Facebook at Fairfax County Consumer Affairs, or visit our website at fairfaxcounty.gov/cableconsumer. See you in April for Consumer Connection. Have a great week.